Ladies and gentlemen, good afternoon. First of all, let me thank the Institute of Cultural Diplomacy for this invitation that came as a surprise, and following the Icelandic intervention, I should say, my idea to accept, but I was fiddling with my agenda, of course, materialized. Now, why was I trying to find the time to come to you and to address you today is because of your choice of the theme for this conference. I do believe that discussing the role of international law and human rights is, well, it has always been very important. Various recent, not only European, but you mentioned also various sort of crisis situations outside Europe simply confirms that this discussion on the role of international law and human rights remains extremely important. So I consider the theme was very well chosen, and this is why I participate in this conference with great pleasure. Now, there will be 2 points I will make today for your discussions. The first point will concern what I would call European vision of human rights, or what is happening with the European vision of human rights. And just mind you, I simply don't have time to develop, but when I say European vision, by no means I engage myself in the discussion that there should be a European vision which is imposed on other parts of the world. For sake of time, and I will explain what do I mean by that, it is simply that since we are in Europe, and Europe has lots of experience and mechanisms on human rights protection, there is a reason to discuss the issue, what comes out of Europe, what is offered by Europe. So it is in this sense. And my second point, that is more sort of for your information, for awareness raising, I will indeed introduce very briefly what is the European Court of Human Rights doing in terms, in the cases relating to the rights of the child and the protection of women, and I hope you will find it interesting as well. Now, as to the first sort of, if you want, policy issue, legal policy issue, evidently this is more inspired by my previous life, where I was academic, and looking at the processes in Europe, and actually being in a way in the middle of these processes through the work in the European Court of Human Rights. I'm making this a more academic, if you want, observation. Now, you will all recall that when the European Court of Human Rights was established after World War II, and when the European Convention on Human Rights was signed in 1950, at that very moment, there was a very specific purpose for which this mechanism was created. And at that very moment, led by Winston Churchill, there was a very clear vision of the need for the protection of human rights as they were enunciated in the European Convention on Human Rights. Now, I'm going to submit to you, and that was already echoed by the introductory addresses to you, that today we live indeed in a different world altogether. Europe has changed, and I would dare to submit that the challenges that modern society has are probably more numerous and certainly more challenging. Now, as far as the work of the European Court of Human Rights is concerned, the difficulty is the following. The first stems from the fact that European Court of Human Rights today, 21st century, is faced with the cases that stem, I should say, from situations which normally arose in the 19th century, before the United Nations Charter outlawed the use of force between the states. Now, we do have cases that stem from the evident use of force between the neighbors, and the court has to deal with those cases. So that's a 19th century situation. The bulk of the court's work, of course, has to do with, I should say, situations typical to the 20th century. That's what the court was, when the court was founded, and the purpose was to indeed deal with those rather typical situations of excessive use of force by the authorities, inhuman conditions in detention places, rule of law issues, lack of independence of the judiciary. I call those, unfortunately, they are daily situations, but I call those the 20th century problems, and I'll come back to that. Now, the court has entered into the types of cases that characterize, indeed, the 21st century. Those have to do with the development of IT technologies. Those have to do with incredibly fast developments in medical science, in research. So the court has also those, not for the moment, not so many, but we are already there. So the fact is, and there was a purpose why I was telling you this, the European Court of Human Rights is, of course, one of the key players on the European stage as it comes to the protection of human rights. I don't think I'm disclosing anything new, anything unknown. But the fact of the matter also remains, and there comes the backlog stories that you have heard, or the amount of work that the court has. The fact of the matter remains. While the states have not done their homework, the court has the whole spectrum of 3rd century cases in front of it. Now, that is, of course, for one institution like that, even as I was told another day, a world-level court indeed it is, but it is quite an impossible task to attend to. And here I come back to the vision, to the European vision of human rights, in a least prejudicial way, using the term European. I think somewhere after the fall of the Berlin Wall, having been, in fact, in my own country, part of the processes that Latvia went through, at that moment, which was the moment of great relief, of extreme emotion, certainly in Europe, in the East and in the West, somehow everything seemed to be very pink, good colors, roses flying. And since then, I have missed, what I am missing is those responsible for European policy decisions coming together and actually agreeing for the 21st century, this is, like Churchill did for 20th century, for 21st century, this is our act together. And I see sort of the work of the Institute and also these conferences very much contributing to this search of what the common human rights vision and agenda should be in Europe. Now, I think that would require sorting the outstanding domestic problems, such as lack of domestic remedies for human rights violations, such as problems in implementing laws and decisions in accordance with the rule of law and transparency principles. Now, those, of course, must be solved, and I think European states in particular, given their experience, can do so and can be a guiding, at least, player in showing where the world as such might want to go. Now, this is One point that I wanted to share with you for your further reflections, I know it opens a lot of sort of possibilities for further reflection, but if you know how the court feels now, then you might be maybe better in a way advised where you should focus your reflections. Now, as far as the protection of children and women is concerned, as you know, the European Convention on Human Rights does not contain specific provisions as concerns children and women. It doesn't have sort of the type of provisions like the United Nations Convention on the Rights of the Child or the UN Convention on Elimination of Discrimination against Women. It doesn't have these specific provisions. However, the court has extensively dealt with cases where the rights of the children and women have been at stake. Now, the court has recognized as the key principle in its judgments the principle of the best interest of the child. So this is indeed our guiding light when we deal with any number of cases where children are concerned. Those cases may have to do with the custody disputes. Those cases may have to do with the implementation of the Hague Convention on the return of the children to their habitual places of residence. They may have to do with juvenile offenders. They may have to do with expulsions of immigrants who happen to be minors. So in all of these cases, under different articles in the Convention, the best interests of the child principle has emerged as the guiding principle. Of course, we have also said, because we have Article 8 on the right to privacy in family life, we have said that a child should benefit from the family, but there are situations where parents simply can't look at each other, and where there is very little that either domestic authorities or even ourselves we can do. In that case, the best interests of the child would be the objective standard against which the decisions of domestic authorities will be assessed. So in all of the decisions, we ask the domestic authorities to evaluate what are the best interests of the child in the specific circumstances of the dispute. Now, the recent authority on this principle is the Grand Chamber case X against Latvia, in which the court effectively found that the domestic courts did not properly assess the arguments submitted to the courts by the plaintiff as concerned the best interests of the child in that particular case. In Saldos against Turkey case, which concerned the presence of a lawyer at the police interrogation, we found that the presence of a lawyer is obligatory from the first moment of interrogation, and that case did concern a juvenile offender. So we said even more so if there is a minor present. In the case Maslow against Austria, we dealt with the issue of expulsion from Austria to the country of origin. In that case, it was Bulgaria. It was a young person who had happened to offend many times, so that was a juvenile offender. But in that case, he had not benefited from the required means of rehabilitation. I mean, if you look at the United Nations standards on juvenile offenders, then you will see that one of the key requirements is working with these minors, and Austria had not provided for that. So it was in this context that the only thing you could think of is to expel to another country instead of trying to rehabilitate, the court indeed felt that was disproportionate and found a violation. There are two recent, I'm sure, cases that will be continue being discussed, analyzed: Soderman against Sweden and O'Keefe against Ireland. O'Keefe against Ireland concerns the abuse by the church of the minors in the 70s, and Soderman concerns the secret filming in the bathroom by a stepfather of his stepdaughter, a teenager, and the absence of legislative provisions that would have allowed Swedish law enforcement to bring charges for such offence. Now, in all of these cases, these are just few, but I think it gives you the already the impression how many of the cases we unfortunately, you could also say, have, where minors are really in the center of the case. And the court has clearly recognized that children are particularly vulnerable. You will see that in the Soderman case, aligning ourselves also with years of work on the rights of the child in at the United Nations level. Now, as far as women are concerned, I wanted simply to say to you that in front of the court, of course, we have applicants, both men and women. And the problems that men and women bring forward, they do not differ in any particular way. There can be the same problems in terms of access to court. There can be the same problems in terms of the lengthy justice. There can be the same problems in terms of treatment at the police station. There are no evident differences. Where there are problems, unfortunately. However, we do have a rather by now, I should say, long line of judgments concerning domestic violence. So far, these cases have concerned women. We do not exclude that they may concern men as well, but so far the cases show that the violence has been directed towards women. Now, one of the, I would say, leading cases that I wanted to refer you to. It was rendered by the chamber. I was at the time, Opus against Turkey, and it concerned indeed a rather grave situation of domestic violence, as a result of which the mother of the applicant was shot dead by the husband. And it actually showed difficulties to dealing with domestic violence, and primarily the fact that the law enforcement, the police and prosecution and the courts are not quite prepared or trained to react where necessary in preventive manner to the signs of domestic violence. And you often would have, certainly in European jurisdictions, that the police investigates if there is a complaint, and if you withdraw the complaint, which is what often women unfortunately do, then there are no clear guidelines for the police force or the prosecution whether to maintain the investigation or to survey the situation. Now, this is a case where the court very clearly established its position. Domestic violence is a lot about special training of the law enforcement and the obligation to protect. It is about the obligation to protect, even in the absence of a formal complaint on the part of potentially the victim. So that is the first extremely important aspect of the case. But the second, I should say, even more important aspect, that is the first case, and the only so far, where the court has found that domestic violence as such is a form of discrimination. is a form of discrimination, and those of you who do follow maybe this issue in particular, and also who follow the expert discussions and the discourse within the context of the United Nations, you may have noticed that in fact this was where the UN discourse in fact arrived as well, noting that domestic violence should be considered as a form of discrimination. Of course, mind you that for UN bodies, which are not courts, it's easier to arrive at some statements of principle. Now, for the court, and European Court of Human Rights works like any other court you might know at the domestic level. For the court to arrive at statement and finding of discrimination, there are the questions of standard of proof, of burden of proof, which in discrimination cases, of course, are very complicated. But we did have enough proof, and the court could also conclude on violation of, in this case, Article 14, which is a non-discrimination article in the European Convention on Human Rights as such. Now, these are the sort of, in this case, so you would imagine there was a violation of the right to life, Article 2, because we had a lethal outcome, and Article 3 as concerns the daughter of the deceased in terms of her own fears, humiliation, and that's the prohibition of torture, which is regulated by Article 3, where we also found a violation. Now, this was very quickly what the court represents, what are the thinkings, the feelings of the court, and how we do our work on a daily basis that is relevant for the purposes of your reflections. And Mr. Chairman, I have 5 minutes and then I have a next meeting. I have to run back to the court. Thank you very much.